We have breaking news tonight about action taken by the Attorney General today to try to implement the president's so-called executive order yesterday aimed at the treatment of children arrested at our southern border and incarcerated. This news has not been widely reported, but this is about a filing made by the federal government in a California court today. This is the filing here. The president's executive order, remember, turns almost entirely on legal actions by the Justice Department to modify the terms of the Flores case, the class action lawsuit that has, for decades, established the rules for the treatment of children apprehended at the southern border. The president's order says, quote, to the Attorney General, the Attorney General shall promptly file a request with the U.S. District Court for the Central District of California to modify the settlement agreement in the Flores settlement in a manner that would permit the government to detain alien families together throughout the pendency of criminal proceedings for improper entry. Last night, on this program, Peter Shea, who is one of the lawyers representing the children protected under the Flores case, told us that the Justice Department had already called him yesterday to tell him that they might go into court today and do this, seeking this modification to the Flores settlement. And we can report now that the Justice Department did exactly that. They rushed into federal court today in Los Angeles with an emergency request, an ex parte request, for asking the judge that first, would the judge in the case allow, quote, U.S. Customs and Immigration Enforcement, ICE, to detain alien minors who have arrived with their parent or legal guardian together in ICE family residential facilities. Second, the court should exempt ICE family residential facilities from the agreement's state licensure requirement. And joining us now is Peter Shea, the president of the Center for Human Rights and Constitutional Law and an attorney in this case. And Peter Shea, they called this an ex parte motion, which means they wanted the judge to actually act on it before even hearing your reply to it, because they say it's an emergency. Will they get an action by the judge, or will you be able to reply to this in some way?
I think it's very highly unlikely that the federal court judge in this case will issue any kind of decision without giving us, the lawyers who represent the plaintiff class in this case, which is all detained minors in the United States. I think it's very unlikely that the judge would rule on the government's application without giving us a reasonable opportunity to respond to it.
And will you oppose the two things they've requested? One, dropping the requirement that the facilities be licensed by the state, have state licensing, and allowing the children to stay with their families or parents for as long as their parents are incarcerated?
Yes, absolutely. We will oppose both of those requests. The licensing is a critical part of the Flores settlement. The licensing ensures that staff at the facility and that the policies and procedures of these facilities comply with well-established child welfare standards for the safety and the well-being of children held at those facilities. We will also, of course, oppose their effort to modify the agreement so that children could be held for as long as criminal or immigration proceedings are pending. That would completely undercut one of the foundations of the settlement, which is a presumption of release for children, unless, of course, they are a flight risk or a danger to themselves or others. So absolutely, we will oppose both of those requests, and I think it's highly unlikely that the court will acquiesce in those requests.
And in general, the court holds that the children should be released within 20 days in general, and that would mean if the Trump administration is going to allow children to stay with their parents, that the parents would then be released within those 20 days along with the child, and that seems to be the big stumbling block for the Trump administration.
You know, it's very unclear what is the stumbling block for the Trump administration. This appears to be more of a publicity stunt. It was not a well-thought-out policy. They had no plan for reuniting these children with their parents. So there doesn't seem to be a strategy here. It's really shoot from the hip. throw some red meat at his base. And in this particular case, many people throughout the country have responded, faith-based leaders, others have responded, mayors have responded with outrage, and I think the court will be outraged at what they have done.
And Peter Shea, the First Lady reported that what she saw in the facility today with 55 teenagers seemed very pleasant. Kids seemed as though they were doing very well. You told us last night that you have about 100 lawyers out there who are getting into all of these facilities because you have unique legal access to these facilities as part of this class action suit. You're legally empowered to visit all of them or any of them. And what are they finding now, and what are they reporting to you?
Boy, they're sure not seeing the same thing that the First Lady seemed to be seeing. What they are finding are kids who are highly distressed, children with suicidal ideation, children who are desperate, who have no idea where their parents are, when, where, or how they'll ever be reunited with their parents or see their parents again. We see children in extreme distress, and for no good reason, for no particular strategy that this administration really has.
Peter Shea, thank you very much for joining us tonight on this important story. Really appreciate it. Thanks for checking out our YouTube channel. Subscribe by clicking on the button below for more from The Last Word and the rest of MSNBC.